Good morning and welcome to our WCCAS presentation this year. Just in case for any of you who don't know what WCCAS is, we are the Western Canada Commercial Arbitration Society, and we are an assembly of some of Western Canada's most experienced domestic and international commercial arbitrators. And all three of us are members of WCCAS. And we're taking on the ever-riveting topic of record disclosure. We're going to do our best to make it interesting, useful, and interactive, so please contribute along the way. Before we begin, I'll just do a short introduction of our panel. So first, we have Mary Comeau. Mary practiced litigation and arbitration law for almost 30 years at Norton Rose, formerly McLeod Dixon, in Calgary. She retired as senior counsel in 2017 and has been a successful and sought-after arbitrator with both the Western Arbitration Chambers and, after moving to Vancouver in 2022, with the Vancouver Arbitration Chambers. Second, we have Laura Cundari. Laura is a partner in Blake's Vancouver office and has extensive experience in litigation and arbitration. While she primarily acts as arbitration counsel, she also serves as an independent neutral. And in 2021, Laura was appointed by the BC government to serve a 5-year term as a roster member for BC's bid protest mechanism and dispute resolution panels. And I am Shannon Hayes. I'm a partner in Lawson Lundell's Calgary office, practicing litigation and arbitration as counsel, and maybe one day making a move towards obtaining work as a neutral. So here's our plan for the session. First, I'm going to provide a short introduction to the topic and what I see as this balancing act between fairness and efficiency in record disclosure. Then we're going to discuss a series of record disclosure topics and issues with this balancing act in mind, with the goal of everyone leaving with some good ideas. Then I'm going to touch briefly on what guidance the case law has provided to date. Various institutional rules, arbitration agreements and statutes set out various objectives of arbitration. The key of these is fairness and efficiency. And while I think there are lots of times when these objectives are aligned, at times in arbitration matters, they appear to be competing or conflicting. We want arbitration to be quick, efficient, and less costly, but we also want to ensure parties are given a fair hearing and an opportunity to both present their case and respond to the opposing case, which then leads to debates as to what is fair, what is an opportunity. Now we're going to deal with two big record disclosure steps in arbitration. Laura is going to lead a discussion on procedural order number 1, and then Mary is going to guide us through a discussion on the Redfern schedule. I'm then going to talk very briefly about some new AI issues in record disclosures as they appear to provide some unique future challenges. And with that, Laura, take it away.
All right, thank you, Shannon. So we had obviously a significant discussion about PO1 already. But with respect to document production, in my experience, this is really often a missed opportunity. Typically, people are sort of recycling the basic description of the Redfern process, and there's not a lot of additional procedure around it in PO1. And I think it was Brad that made the comment that we should have our clients at PO1, they should be involved in commenting on PO1, and document production is actually one of the most important things to clients. It's a huge cost focus for them. They may have sensitive documents that they're concerned about. And so this is, I think, an area where we need to focus on innovating a bit more to make arbitration more appealing to clients that are perhaps a little disillusioned with it sometimes. So I know we have a variety of people in the audience, from expert to just learning about arbitration. So I'm going to just talk about a couple basic things to include, some things you may not have thought about, and then we're going to talk about a different scenario and maybe get some views from the audience about how you'd handle it. So the basics, things like keeping hard copies to a minimum, authenticity is presumed typically in PO1, Interestingly, that is now something people are maybe reconsidering with a lot of AI and machine generated documents being produced, whether we need to think about that a little more carefully. And including provisions for things like translation of documents and how that's going to occur. It's helpful to refer to the IBA rules, and in particular Article 3 and Article 9, which speak to the potential bases for excluding or objecting to the admission of evidence. It gives sort of a basic understanding of some of these key principles, particularly where you have a party that maybe is not as familiar with how document production works in arbitration. A couple things I've seen that I think are good value adds are building in a scheduled meet and confer between counsel, requiring them to cooperate on narrowing the contested requests before they're submitted. In my experience, that is actually very successful. Adding in language providing that if a party is objecting to a request based on it being overbroad, that they must propose an alternative formulation. And the tribunal might also specify that instead of it narrowing requests, it will simply deny requests that are overbroad. That tends to keep people a little bit in line. Consider also a limit on the number of requests a party may make. And that might feel a little uncomfortable at PO1, but if you have a subsequent procedural conference, as was suggested once perhaps the first memorials have been exchanged, that may feel a little bit easier to do. I've also seen even word count limits for the cells or boxes in the schedule. And Mary's going to talk a bit about document exchange schedules. But you sometimes see what is intended to be a summary chart go on for pages and pages, and it becomes totally unmanageable. So that's something to think about as well. Thinking even more outside the box, if you are counsel on a very simple, or your tribunal or counsel on a very simple or perhaps an expedited process, consider whether the Redfern process is the right process. If there are going to be a very small number of documents, it may be simpler for the parties to just provide a simple list. And I think we need to think about ways to not become too rigid in how we think arbitrations have to run. So the scenario we wanted to discuss was you're sitting as a sole arbitrator on an international arbitration between two entities. One entity is located in Canada and has retained Canadian common law trained Canadian lawyers. The other entity is Swiss, and the lawyer it has hired is civil law trained. The parties have asked you to propose a form of procedural order for them to consider. Your standard PO1 includes a simple description of the usual Redfern process. Are there any modifications you should make in this scenario? And for those that aren't aware, there are can be quite significant differences in the two legal traditions, particularly outside North America and within North America. So common law lawyers, as most of you will be familiar with, rely on witnesses to present a narrative of what happened in the case. Civil law lawyers prefer to rely on the underlying documents, and witnesses may play a more minor role. Common law discovery tends to be much more far-reaching, and in civil law jurisdictions, there's limited production. The parties are to present their case, and there's not a lot of mandated discovery. So any thoughts about how you might go about sort of bringing these two traditions together in PO1?
So I will start off by providing some general comments. And following up with the Brian and Stephen's great phrase, I think we'll start with it depends. And I think a lot of it depends on the size of the case and the sophistication of the parties. But I think it would be important to have a meeting rather than just leaving it to you to draft something, to meet with the parties and make sure that each understand the perspective of the other, or have them explain their perspectives rather than you assuming what their perspectives are. Meet with them, understand their perspectives, and explain to them sort of what's typical, in an arbitration procedure in terms of document production, how red ferns work, how other schedules work, and work with them to come up with something that's most appropriate in the circumstances. And I'm going to talk in a bit about particular schedules. But I think the most important thing would be to have the lawyers and their clients in a call or a meeting to work through what the expectations are, try and get them to some common understanding or agreement on what the general scope should be. And ultimately, if you had to decide because they came from these two very disparate perspectives and could not agree, then I think you have to take a step back and look at the case and decide for yourself and the tribunal what makes the most sense in the particular case, and draft that for the parties to consider.
Other thoughts? Yes.
Presumably, though, this problem is not new. And how has it been dealt with typically in the past? You know, by where we've had like common law lawyers and civil law lawyers having to try to deal with this situation. What has been the practice? Yeah, okay, shall I repeat with the mic?
Sure.
Okay. I mean, presumably this problem, though, is not new. I would assume that it's probably reasonably common that you do get common law lawyers and civil law lawyers having to try to address this issue. And what has been the typical practice in the past, or can one even make any generalizing statements at all?
Well, I think that's traditionally where it's thought where the Redfern schedule did come from, and the requirements that it sets out in the IBA rules was to try to bring together these two views in a way that kind of balanced the various interests. But I'm hoping that we might generate from people in the room other ideas that you can add to the Redfern schedule, or approaches that might take us beyond that, because I think my own experience is that the Redfern schedules to a large degree and can devolve just into all the same issues, because things like a defined category, well, some people think that's a fairly specific request, and other parties will say, my ask for all the accounting documents from this period to this period is a defined category. So trying to deal with some of those issues that come up. I don't know if other people have tips and tricks that they have used to try and address those types of issues.
So in some more complex construction matters, it's been my experience that during the meet and confer process, thinking through a document exchange protocol and the scope and handling of that information can often lead to a lot of cost containment and getting in front of a lot of the document exchange issues that occur later on in an arbitration, if those are handled and agreed upon early on in the procedure.
I can say that any time where you're kind of at a crossroads, it's much better to get counsel in a room and try and work through things than just do a letter writing campaign back and forth, or just immediately go to the panel. Especially the panel would often, their first question is, have you tried to work this out? And we've even, like, I had a case where there was a fight over privileged records, and they thought they weren't privileged, we thought they were, and we actually had a without prejudice meeting where we showed some of the samples of some of these records, just to establish that there's nothing here, and to substantiate it. Same with irrelevant records, like we've done that in the past as well. So I think even just to have, it doesn't necessarily even need to be one meet and confer. It can be kind of a check-in regularly, like, what do we think this case is about? And okay, you're asking for these records, like, why? What's your theory of the case? And I think it's okay for counsel to share that. I don't think you need to wait and sandbag your opponent at the end. If your case is strong, it'll be strong throughout.
Yeah, I think the biggest risk is if you don't at least think about these issues, because even with a Redfern process, which is hopefully able to bring the parties together, parties from different legal traditions will have different views about things like confidential documents, sensitive documents, problematic documents. And so if you have those discussions in procedural conference number one, you can get a sense of where the parties sit and make sure that you're at least alive to them, so that these issues aren't hidden and then they arise when the parties actually producing documents and things are missing that are not there, and you're trying halfway through the process to deal with them, which can derail the arbitration process.
This might be obvious, but especially if you're sitting as arbitrator and the parties say want a reference schedule, I think you need to bring it up just to ensure that everyone is on the same page in terms of relevancy. So is it relevant to the case and material to its outcome, or are you using some other view of relevancy? Because that has to be dealt with up front. It might be obvious, but not always.
Yeah, including what the document production standard is within the PO number 1, I think is important, and even defining what relevant material is, because it's pretty broad sometimes.
Yeah, so when Mary talks about schedule, she's going to talk about one form of schedule called an Armesto schedule, and with that, there's a procedural order, a model procedural order that has very detailed explanations of what would, for example, be an appropriate request. There are drafting samples in it, detailed explanations of the types of objections that would be appropriate. So that would be something that would sort of ensure that everyone's on the same page about what we're talking about in terms of appropriate requests and responses.
Any other questions or tips? Okay. Well, with that, we'll move on to the Redfern. And Mary's going to take us through a discussion on that.
You might be happy to know that I'm actually not going to talk about Redfern schedules that much because they're not that interesting. But I mean, just to go through the schedules that are sort of presently in circulation, there's obviously the Redfern and the Stearns, which are quite similar. And they all have, they track the requests, the objections, the replies, the arbitrator's decision. One's horizontal, one's vertical. You have debates about which one's easier to manage and which one isn't. And I think they have a good place. And I think, Redfern's usually in the procedural order also adopt the IBA rules. And so you're in that whole framework. And I think, to the point earlier, when you have parties coming from two different legal backgrounds, it was a really good background and backbone to try to start to bring those parties together as to a process that might meet in the middle, respect both of the traditions, and hopefully make everybody happy in the process. I think the Armesto schedule is newer, and I'm curious, as a show of hands, as to anyone here, either arbitrator or counsel, has been involved in an arbitration that used an Armesto schedule. One hand over here. Well, you're going to get all the questions, my friend. Oh, interesting.
So not new.
Right, yeah. So it has been around for longer than a lot of people think. And it is a variation of the Redfern schedule. But I think, as Laura pointed out, I think what's interesting about the Armesto schedule is the things that it incorporates into the procedural order. And there's some good articles out there on Armesto schedule, so I won't get into all the detail, but they are sort of a refinement of the Redfern schedule in a number of ways. First of all, they're color-coded. So for an old person like me, that's great. I like a document where I can look at it, and there's a color coding for the request, the objection, all the replies. So you can see easily what column it is that you should be looking for, depending on what you're looking for. It uses a single page for each request, so you don't have a zillion. People don't get into that, 0.5 point to try and keep their schedules down to 50 pages. And it sets out the IBA requirements and then the various objections. And as Laura points out, the schedules often give fairly detailed examples of what is a reasonable request and what is a request that fits the definitions for relevant and material. So it's helpful in those ways, and those are all good to look at. But it also does some other things that it incorporates into the procedural order, which I think are super helpful. One is it uses affidavits. So there's two different affidavits that the procedural order adopts within our MESTO schedule. One is a declaration by the chief legal officer of the client producing the documents. And that affidavit, or sworn declaration, says that they haven't destroyed any documents, they've done a reasonable search for documents, and that they've produced all the requested documents. And there's a second declaration that is sworn by external legal counsel that says they've explained those obligations to the client understands the obligation. So a lot of times in international arbitration, you have parties where they have very different approaches to whether documents need to be kept and whether documents need to be produced, etc. So I think those affidavits bring a lot of comfort to parties that the process that they expect to be followed has been followed. Another aspect of the Ernesto schedule that I think as a tribunal member is helpful is that in the procedural order, when you adopt an Ernesto schedule, you usually include a specific provision about allocating costs. And that says that the tribunal will take into account the party's reasonableness in the document production process, the costs of the parties in terms of, and parties are expected to make specific statements on costs in terms of, that's overly broad, it's going to be prohibitive to produce, we'll produce it if we're asked to. And they're to put in their statement of costs what it cost them to respond to the requests that either the other party made and they agreed to comply with, or that the tribunal directed them to comply with. So oftentimes, by the time you get, I'm sure we've all had this experience, I had it as counsel, where you have someone who's kind of jacking you around in the document process. And then by the time you get through the entire process and you get to a hearing, you get to a decision, and then you're looking at costs, that's all very much in the rearview mirror. And so parties aren't really incented to be reasonable in that process because it seldom really gets put under the microscope later on down the road. So I think in the procedural order that's adopted with an Ernesto schedule, it's really helpful to make it clear that the parties are required to make submissions on costs that relate to the production of documents, and that the arbitrators are required to take that into consideration when they're determining costs at the end of the day. So there's the flag for Ernesto schedules. It's interesting. They have been around a long time. I don't know that they're used very often. Certainly the experience in this room would suggest they are not. But I think they're worth taking a look at and certainly thinking of some of those good ideas as to what you might want to put in your procedural order, regardless of whether you use a Redfern or a Stern schedule. The last schedule I wanted to mention just briefly isn't really a document production schedule, but as a tribunal, I think you can sometimes use it to your advantage, and that's a Scott schedule. It started out sort of relevant to family law. I've seen it used a fair bit in construction matters, and that's a schedule that just where the parties set out, these are the issues in dispute, here's what that issue is worth, here's each party's position on that issue, if there's references to particular contractual provisions, and just kind of a very brief summary of each party's position on it, and it's sort of an issue tracking device. But I find having one of those done early on, they're often done in the pre-hearing time frame, so before you go into the hearing, it just lets the party set out, here are the issues still on the table, here's each party's position on them. I find if you do one of those really early on, and if you have one adopted in your procedure order number 1, it can really help with document production, because then whatever schedule you're using, you can ask the parties to tie their request to the Stern schedule. And that really helps as an arbitrator to help you get the parties to focus on what issue is this going to. How we're doing for time.
You're good.
We're good, okay. So all these various schedules, what are they trying to do? They're trying to help parties focus on document production, help the tribunal figure out what's really going on. And how well do they work? Well, I have had a handful of cases involving really complex commercial relationships, about 3 or 4 of them that related to manufacturing, supply chain. There was an aspect of construction. There was a lot of parties relevant to the dispute, although the dispute itself was just between 2 parties, and lots of documents. And it became very complicated in these cases for the tribunal to figure out realistically a number of things. One was, what the heck is going on? Like, what document are we looking at? What's been agreed to? What hasn't been agreed to? And then secondly, how were these relevant to a very broad range of issues? So I want to take you through a sample that is a real life example from about 2 years ago. And it starts out as a nightmare, but it also, I think, highlights some things that, on the theme of the thing, a good idea at the end of the day, and it did work out well. So it was one of these large complex disputes. I went back and looked at it after our discussion the other day. So the initial party's request, Party A, they were using Redfern schedules, and it was prior to either side filing their case. So they had filed their pleadings, then they exchanged Redfern schedules. Party A had 52 pages of Redfern requests. Party B had 76 pages of Redfern requests. Each sought parties from third parties that were related to the matter, subcontractors, related parties of the parties. There were categories and subcategories. We had, AA 1.5.5 request sub B. Like, it was a nightmare. Each responded to the other. There were many refusals, and which then resulted in each Redfern schedule being over 100 pages. Then each replied to the other in Redfern form, which then resulted in 200 pages each of Redfern schedules. So the arbitrators now had 6 documents in column form with detailed arguments, and literally the columns would go on for like 5 pages of like, here's why we're not producing this. And you try to go back and figure out like, what are they even talking about at this point? Then the parties really helpfully got together and would periodically agree on certain things, and you need to narrow this, and could you re-describe that, which then resulted in several more iterations of these Redfern schedules coming to the arbitrators. Finally, then the parties decided that they wanted a week of hearing to determine the objections on the Redfern schedules. So as a tribunal, that's a real dream. You're just like, I can't wait for this week. This is going to be fun. And remember, at this point, we have no witness statements, we have no arguments, we have nothing. So what was the good idea that came from that? It sounds like it was a nightmare, and it turned out to be okay, but the takeaways for me was, this has been mentioned a couple of times today, and that is, do the Redfern requests after the parties have filed their case. And we talked a lot about witness statements and experts' reports. I am also happy to get a brief, and a lot of young practitioners, when you say you need to put your case in, they say, well, I won't know because of our position in this case, we couldn't possibly put a brief in until we have documents. And I always say, I'm happy to hear an argument or a brief that says, this is what we expect the documents will show, and so here's what we're arguing. And if at the end of the day that's not what the documents show and you say we're abandoning that argument, I'm fine with that. I don't look at that and say, well, that's somehow a black mark on you. I think that's okay. But it's hugely helpful to have some idea as to what the case is about as a tribunal, obviously, before you're just trying to figure out these myriads of documents. The second thing that I would suggest counsel really think about, and I think it was mentioned earlier, is at some point, if you do have a lot of disputes and you are going to a hearing, be it a half a day or a week, reorganize the materials so that there's a hope that the arbitration panel will understand which ones you're talking about, which ones you've agreed to, and which ones are still on the table. Because it's helpful that that happens, but and it's just administrative. But if you have this ongoing enormous monster of a document, it's very hard for the tribunal to even figure out what it is they're still ruling on and what the modified request is and where that should fit in. So I think reorganizing all the material so that everyone can focus on what requests are being objected to and what requests have been agreed to is really helpful. So putting them into categories from each party and having the parties argue the ones that are most relevant or mostly the same is very helpful. Putting materials into a brief and getting rid of all the crazy columns, also very helpful. And what happened in that case, and I think what often happens, is that process devolves almost into a case management type of process. And we ended up in that particular case not spending a week. We spent a day, and then the parties went away for a half day. We spent another half a day. Then the parties went away for another day, and then we spent another day. And what was great that came out of that is the parties were able to come to agreement on a whole lot of things. And the arbitrators obviously had a much better understanding as to what the case was about. And the parties had a better understanding as to what the tribunal thought was important for it to understand. And so the nightmare turning into a good idea is that a lot of times I think parties think, we're going to have a hearing on the reference schedule. This is just cost and this is just painful. And in a lot of cases, it wouldn't be necessary. But in complex cases, it turned out to be extremely helpful and frankly, probably the most efficient use of time. And it moved the case forward quite substantially. So that was the nightmare case, and those are the good ideas.
Thanks, Mary. In a previous iteration of our presentation, there was Dan McDonald shared that he had a similar hearing, and he quickly transitioned it into a med-arb, and where they could just have frank discussions, being like, "Why do you want this record? Tell me, you know, and why do you say it's not relevant?" And he said they resolved a bunch of them over the course of just one day, and it was a bit just going through the list, but. It took a full day, but it prevented a lot of letters and briefs going back and forth. So he found that that was helpful. And then one other idea tied to that, I was listening to another speaker, a very senior arbitrator, and he said, counsel, be confident and jump off that cliff. Like, especially I think if we come from a commercial litigation background, we think, I want to see the whole lay of the land before I come up with a theory of the case, and I want to turn over every stone. And to Mary's point, just go for it. And if it changes, it changes. But make your arguments known and go with a theory from the very beginning. Laura, any comments?
Yeah, I'm interested in your comment, Mary, about the oral hearing. And because we are quite hesitant to typically do that. Do you think that, you know, we sometimes get caught up in these schedules and they get totally unwieldy, where having just a short procedural conference would be more efficient?
Yeah, I think that's right. And I think I think you can see it in the writing, and I'm sure arbitrators sitting here have seen it, where you can just see these parties getting more and more locked into this fight where they're just banging on each other and saying, you know, repeating the same things. And so there's nothing like having to stand in front of a tribunal, and it's in a small room, and not being able to just continue that. And you can kind of break that logjam by saying, I hear what you're saying. I hear what you're saying. Here's where I'm struggling to connect the dots. I need you to help me with that. And I think having clients in the room for those hearings is really helpful. I do think generally counsel gets more nervous. And the one that I was involved with, it was counsel who was leading the way in terms of, you know, we would ask a few questions about their arguments, they'd ask for a break, then they'd come back and say, counsel, have had discussions in light of your questions, we'd like to go away, and so I think it was more, I think it made them less nervous as the time went on. They intended to argue it as an application, but they quickly saw that I think the value was more in having it more kind of as a meet-arb on the document issues. And that was really helpful. But I do think a lot of counsel are less comfortable with it and just want to stick with the legal arguments. And it's very difficult for a tribunal in a complex matter with nothing but the pleadings to try and figure out what's fair and efficient and what's not going to get turned over later because something that on the face of it didn't seem particularly relevant turns out later to be relevant. And obviously that's the balance that you're trying to make. And every time a party is asking for a document, their prime backbone to their argument is this hearing will not be fair if I do not get these documents. I couldn't possibly make my case. That's why I like the Armesto cost issue being put in the procedural order, because I think that holds council's feet to the fire much more in terms of making what might sometimes seem to be exaggerated arguments as to the importance of some documents, when really they may really be more on a fishing expedition trying to find something that may be there, or that they think may be there but isn't really. I'd be curious to find out from other tribunal members, have you found any effective techniques to try and get parties to narrow the description of categories of documents? I find in the 5 years I've been sitting on tribunals, parties' descriptions of categories have become broader and more broad
Any
and more
and all
broad.
records related to the operation of the facility.
Yes. Can you narrow that from this year to this year? Like, that's not helpful. But when you don't know anything about the case, it's very difficult as the tribunal sometimes to try and put reasonable boundaries on that.
Thanks very much. I'll maybe make a comment on that, not necessarily as a tribunal member, but it does raise an interesting point about the support structure that is really important for managing the Redfern process, or the adjusted schedule process that's been described. And in fact, a lot of these adjusted schedules sound very interesting to me, and potentially very helpful. I'm going to get the name wrong, but the Armesto schedule, for instance, raises the possibility of an affidavit from legal officers. That, to me, sounds like quite a lot. Maybe something the parties, touching upon a point from our last panel, might together agree not to do. But it does, for me, raise the concept of a support structure around tracking exactly what steps have been taken in respect of each request, so that in the case of needing to narrow a request, a tribunal can ask council very quickly what has been done to bottom this request out. How would you go about doing it? And just having that record of exactly what's been carried out in order to meet the request, or what will be carried out in order to meet it, is helpful, I think, in scrutinizing whether enough has been done. It also, I think, there was a description of from Professor Jones in our last panel about expert-driven Redfern schedules, which is another sort of interesting approach, and I think very fruitful in a lot of cases, but also requires some support structure. And here the conversation about hearings for document production seem to be particularly apt, because when you have experts, it does seem to me that some of them are excellent experts with a lot of experience in working with tribunals and may be able to navigate this scenario very well. Others are called upon to provide expertise maybe for the first time in their careers and need assistance in describing their request, describing the technical matters, and it's far easier for them to do that in person rather than in writing, because it just is the way that they communicate, and they're not quite able to set out exactly what it is they're looking for in writing. So I guess the point is that the structure, the schedules themselves are important, but it's the support structure behind the scenes that I think really makes them highly workable. And I wouldn't dispose of the importance of the hearings and the record of the work that the council has done in order to give some real sense to these potentially broad-reaching requests.
Now, obviously, the easy thing for the tribunal to do in the backstop is to say, this is too broad, and if you can't narrow it, you're not going to get it. But you always, you hope that council gets that's the answer at the end of the day. It's also frustrating as a tribunal member to get just a request saying, because my expert needs this. Recognize that that's interesting, but why, and what does your expert have to say about that? And I've been involved in a couple, particularly on construction, where experts have been involved for a long time because of the nature of how those files unfold. And it's always interesting to see that this party's expert has issued various reports throughout that have led to various things happening during the construction process without ever asking for these documents that now appear to be vitally important to them now that we're in an arbitration process. So sometimes there's reasons for that, but other times it seems to raise some questions that I think need to be addressed by hearing from the expert or hearing through counsel specifics as to why the expert needs the documents that are being sought. Sure. Can we get a mic down here? In front of the pillar.
Yeah.
Once again, I'm in front of the pillar. So having acted again as an expert and also as an arbitrator, a couple of things that are possibilities is selling the services of non-lawyers on the panel as part of the tribunal members allows us to sometimes look at the requests from a different point of view and understand specifically what's being asked. Another approach is to potentially have the experts come to that hearing and sort of a little bit of hot tubbing or whatever you want to call it, or have the experts meet without anyone else and come back with a joint list of the documents that they need. Excuse me. As a case progresses, quite often what you need actually does change. But sometimes, as you mentioned, all of a sudden there's new documents that came out of the middle of nowhere that maybe have nothing to do with the expert that counsel is just trying to get in. So having an expert on the tribunal or having the experts get together during that process can be very, very helpful.
Thanks. I'd like to follow that comment from Farley with another comment as a non-lawyer on the panel, and that is the 80-20 rule. And as a business executive, what you're always looking for is that 20% that really counts for 80% of the impact. And I think if you ask that same question to both parties and get them to narrow it with that in mind, and listen to their answers, and then even repeat that question again on that 20% and get them to drill it down, narrow it down, you can get to the real heart of the matter, which is what you're looking for when you're trying to make your decision. So everybody wants to put everything out there, but what you really want are what are those few points that are really going to carry the day. And I think that's a standard practice as an executive, and can be a very effective practice as a member of the arbitral panel.
I can't remember who made the comment earlier, but had a similar experience to mine, which started 30 years ago, doing arbitrations when it was thought to be faster and better than court and all those things. And it's unfortunate to sit here many years later and still have the situation that in almost every case where your 80-20 rule, you end up with 50 binders and everyone refers to the same 15 documents in binder number 1, and the rest of it never gets looked at. And I appreciate some of it goes into expert reports, and sometimes there's a lot of documents that need to be put into accounting, programs and things like that. But a lot of times it's just a bunch of meat in the grinder that no one's ever looked at. So. And it's sad to sit here this many years later and find that that's still the case.
I think that was Louise Barrington's comment, and I just wanted to add my name to it, Paul Tischauer, so that everybody knows where it comes from. Thank you.
Any other comments or questions? Okay, moving on. I just want to raise a couple issues. We talked about AI and the new implications for record disclosure moving forward with AI issues. And sadly, I have no strategies or answers as it's on the cusp of practice. But some issues that we became aware of as we kind of dug into some of the information out there. Obviously, AI needs to be considered now moving forward in your preservation and as well as part of your record requests, particularly in certain cases where AI may be more at use. Laura raised earlier authentication and admissibility issues for pure AI created records. There's no human that can say, I made this. There's a bit of a gap there. Issues of AI documents creating false information or hallucinations. And coupled with that is issues of AI creating inaccurate business information or legal positions. I have a friend in-house, and any kind of more straightforward letter agreement, she gets ChatGPT to write for her first. And of course, we know that there's certain cases that on contractual interpretation cases where drafts become this big fight about what happened and the intention of the parties. And so if you're starting with a draft that's just from the ether, and isn't really linked to your business at all, and might contain a bunch of inaccuracies or positions that you may not even take as a corporation or legally, that draft contains that. And so then if later it's changed and modified, there's questions as to, well, why was it changed and modified? Well, because the AI drafted it. But the implication is, well, but it was your company's record to start with. So you clearly must have had this position at the very beginning. So it kind of creates this starting point of these records that then need to be explained away in certain circumstances. The other big issue would be the application of privilege. So you could have in-house counsel who are getting legal advice from ChatGPT or other AI models. And does privilege attach to a record that's been generated by an AI model? Is the AI model just an extension of counsel, or is it a third party that's essentially not a legal practitioner? And then, of course, the potential waiver of privileged information that's been put into an AI model in order to garner some kind of a legal position. If a company employee is sharing a bunch of information that's privileged in order to get ChatGPT's views on what it might be, is that a waiver or is it still protected? So no answers. But just some things for you to be alive to moving forward. Finally, I'm just going to speak to some of the guidance that's coming out of the case law on this balance of efficiency and fairness within the context of record disclosure in arbitration. Our domestic arbitration acts reinforce this procedural fairness through the various sections, including the two that are quoted above from Alberta and Ontario, and they all contain similar wording. And the courts have been interpreting this in set-aside applications. And the majority of the cases of set-aside applications that includes record disclosure involve issues such as a refusal to accept very late disclosure, a refusal to order disclosure, refusal to order third-party disclosure. And these refusals are all then alleged to be unfair and prevent a party's ability to present their case or respond to a case. And some have even argued in certain cases that it switched the burden because you then don't have the evidence in order to prove your case. And so what have the courts said so far? The Alberta Court of Appeal in the NMAX TransAlta case provided the following, which each individual point kind of creates a bit of guidance for us. So in this case, NMAX and the balancing pool brought a set-aside application on the allegation that the tribunal made a decision in the award based on the absence of evidence that they had asked for. It was a lot more complicated than that, but that was the central gist of it. And the Alberta Court of Appeal provided guidance on what parties are entitled to, including that a hearing need not be perfect, and you can't look at each individual document disclosure ruling as an isolated instance. It needs to be captured and looked at within the whole context of the arbitration. And not every refusal to admit evidence is a breach of natural justice. So what is? It's something significant. It's one of the 15 documents that hasn't been produced. In the case of record disclosure, the excluded evidence must have been crucial to the case in order for its absence to negate a party's opportunity. A more recent Ontario Court of Appeal case of All Communications and Planet Energy dealt with a set-aside application on the basis that the tribunal refused leave to Planet's request for an application about deficiencies in all communications disclosure. So Planet had asked for certain record requests. All Communications provided the records, but they did not produce the records of a third party that they were working with. Planet then went to a US court and got an order for this third party producer to provide its records. This third party produced those records after the hearing, but before oral submissions. And the tribunal accepted the production and reviewed it. And included it as part of its award. It considered it as part of the award. And the Ontario Court of Appeal set a fairly high bar. It found that there was not a breach of natural justice and did not set aside the case. And there were two things that were kind of interesting in this. One, the Court of Appeal really found comfort in the arbitrator's detailed award in acknowledging that the evidence was admitted, considered as part of the award, and that counsel did not make a request to recall any witnesses or to ask for any new witnesses in order to explore these new records. And so if counsel didn't complain and didn't ask for this opportunity to cross, and the arbitrator did consider this evidence, then it was not found to be a breach of natural justice. Now, in the whole exploration of what set aside might be successful in a record disclosure case, there's the syndicate, the Supreme Court of Canada 1993 case. And that's, I think, the only case we found that was successful in a court setting aside an arbitration award as a result of a record disclosure issue. And in that case, so it was a labor relations dispute. The University of Quebec had hired two contractors, had then let them go, and their explanation was that there was a lack of funds. They, of course, the two contractors made a complaint, and there was an arbitration. And the University of Quebec wanted to introduce evidence that the two contractors were very poor employees, and as a result, they had to hire a third employee, which then led to the lack of funds, and so the program ran out of money too early. In this case, the arbitrator said the University of Quebec could not bring its own evidence in, and found that there was not a lack of funds. And so in this case, the lower court, the Court of Appeal, and then the Supreme Court all agreed that in that case, the arbitrator found against the University of Quebec on an issue that Quebec had the burden on, but was prevented from bringing its own evidence in order to prove. So that's one case.
Yeah, I think underlying all those cases is the difference between court procedure, which is compulsory, and arbitration, where you agree to a set of rules and a procedure. And most of the cases, the party either didn't fully grasp what was happening with the procedure, wasn't paying attention to it, or was not in compliance with the procedure. And so there is no breach of procedural fairness because they haven't followed the procedure, versus court, where you know, you are required to follow this. And so there's a lot more leeway to make sure people are given the opportunity to present their case within that compulsory system.
Any questions or comments? Yes.
Beyond the nightmare of Redfin schedules,
That should have been our title.
where Alan's surname is rarely used without a pejorative adjective in front of it, there are three issues I thought I might just mention: privilege, determination of privilege, and protocols which parties agree for electronic disclosure, which in my experience have proved to be quite difficult. Firstly, in relation to privilege in international matters, there is, of course, a vast difference between jurisdictions as to whether there is, without prejudice privilege at all, litigation privilege, and there are often claims for privilege arising from executive privilege of governments and national security privilege. In that context, it's very difficult, until you know what the documents are and where they're from, to make rulings in advance as to what the principles will be. And in many instances, parties are unwilling for tribunals to see the documents that are the subject of the contested claims. So the first issue is understanding and dealing effectively with the differences of principle associated with those four categories of privilege. The second is the use of referees by the tribunal to actually rule on documents where the parties are unwilling to allow the tribunal to see the documents to make the rulings. And thirdly, I've struck some really vigorous disputes about whether parties have complied with agreed document production protocols for electronic documents, and have found the need in a couple of cases to actually appoint experts who deal with document production electronic issues to determine which party's argument about whether there's been compliance is necessarily appropriate or not.
Thank you. Yeah. Fights over metadata.
I think the point about having referees appointed for privileged documents is a good one, and I think that is used fairly often, and I think it is a good way to make sure that those issues get fully looked at and the parties are happy that the ultimate decision makers aren't seeing anything that they shouldn't at the end of the day have seen. So I think that is a good reminder that that is always a tool available in those fights.
On the electronic disclosure issue, I have not used this, but I've heard people recommend it to me to use a joint database. So instead of each individual party, doing their production, and then council's got to, or arbitration panel's got to figure it out, have something, you all agree on a certain service provider, and everyone's loading up their records, and it's accessible by everyone, including the panel. Anyways, one tip, have not used yet.
And as a tribunal, I find it's nice when you have those service providers, because then that service provider independently deals with the tribunal. So when you have questions, you're not going to the parties and they're not going, oh, well, they're all looking at these documents, or they all really want to understand the background of these documents. And you address that with the parties, and they agree that the service provider will confidentially deal with those types of requests from the parties. And it makes it much easier as a tribunal member to get the detail you want about the documents you want without causing a big kerfuffle amongst the parties.
Okay, our time is up. Thank you. And make sure you cheer loud for the Oilers tonight.